Good morning. Thank you. Please be seated. We are here in our cause number CV140615 involving Lori Curto versus Anthony Curto. This is the time set for oral argument. Each side will have 20 minutes to argue. Appellant, if you'd like to reserve time for rebuttal, we will let you manage that clock. It'll be right in front of you. There will be an audio recording of the argument. So as you come forward, please identify yourself and your client. There's also a video recording which will be available on YouTube within a week or so, maybe sooner. We have read the briefs, we've conferenced this matter, we understand the issues that are being posed, and with that in mind, counsel?
Good morning, Your Honors. I am Diane McCulloch on behalf of Anthony Curto, appellant, respondent in the underlying case. Generally, Mr. Curto relies, our father, I'll refer to him as father, relies on Milanovic and Cummings with respect to the issue of child support. Father has asked that mother be attributed a certain amount of income. The disagreement is how much of that income should be attributed to mother. The trial court only attributed part of her income, which was clearly her income. She was taking it as income. She got income tax, filed the income tax returns on that income, whether it's inherited or based on a 401k or some other retirement account is not distinguishable. I mean, clearly it's not.
What's your understanding of why the trial court did not include all of it? Was it because the trial court did a post-tax, after-tax, rather than pre-tax?
No, the trial court didn't do that at all. It just found, what it did is, well, the last one was added wrong. Didn't add the 1099s, but subtracted out amounts from transfers from one account to another. But a 1099 is what the income is. And the trial court subtracted out money from that. For the prior child support purposes, the court also subtracted out $2,900 a month for attorney's fees, when clearly mother wasn't entitled to attorney's fees, and subtracted out health insurance. Didn't do the same for father. Doesn't do the same in any case. In any case, a parent's income is a parent's income. It's what their W-2s or 1099s reflect, added up, divided by 12 months.
Was the deduction for fees based upon some order, or just because she was paying her counsel fees out of that sum?
Right. There was no order for attorney's fees whatsoever, except to my client, and that's the second half of our brief.
Before you go on to that, the 2,900 in fees, was that in, where did that number come from? Is that based on the affidavit of the AFI? Is that from the AFI?
Yeah, what she had spent on fees for this litigation. He just subtracted it out, saying it's not available for the children because she wasn't spending. The trial court's reasoning was because she's having to spend this money for this litigation, it's not available for her to spend on the children. That was the trial court's reasoning behind the subtracting $2,900 per month from what was clearly her income. Additionally, the trial court subtracted out $1,500 a month from her income for her health insurance. Well, father's paying health insurance too, and in every case somebody's ordered to pay health insurance, and not for the children. We're not even talking about the children where she did get credit on the child support worksheet. We're saying for herself. So then in every case we get to subtract out our attorney's fees and whatever they may be and our health insurance for ourselves, so we have to pay a lesser amount in child support. There's absolutely no logic behind that.
At least it doesn't seem that would be supported by the child support guideline direction.
Or Cummings or Milanovic.
What is your calculation, at least approximately, of what should have been the attributed income?
It was 17,000.
Yeah, that's.
Yeah. 17,212.39 per month.
The judge says father wishes to attribute 17,212.39 a month.
Correct. And he subtracted from that.
On appeal now, you still believe that's the correct figure?
Yes, we do. And we get that figure from what mother spent every month. It was a simple calculation. That isn't even, she filed income tax returns reflecting income of $300 and some odd thousand, which reflects $30,000 a month. We didn't ask for that. We asked for what she was spending on a regular basis every month, just average it out every month. Judge Porter, mother made the argument also that because she was spending it on improving assets, some of it was attributed to her improving other inherited assets that.
An investment rather than living expense.
Correct. That argument was made. We subtracted out those expenses. For trial purposes, we subtracted out all those and just what she was making, less what she spent on other, reinvested, and made the argument, and that's where we came up with the $17,000 per month. We took her income, subtracted out the improvements to other assets, and came up with the $17,000 per month.
But you're asking us to send it back for a new calculation.
Correct.
Yeah, you're not expecting us to make the calculation.
No, not at all. For demonstrative purposes, I attached what the difference would be.
And I was just asking about it for education, my own educational purposes.
And this is only for arrears, correct? There's nothing going forward at this point? Are the children 18 now?
The children, yes, have turned 18. Yes,
Graduated from high school?
yes. Both graduated this year.
Just within the last few weeks, I suppose. Maybe.
Yes.
Yeah,
I think they turned 18 in April and they graduated in May.
yes. So they're off the child support figures now.
Right.
Okay.
And the other issue is the issue of attorney's fees. And the issue of attorney's fees comes up because Judge Porter, though recognizing the disparity, father's income is $17 an hour, where mother's income is $17,000 a month, giving her credit for the assets and the improvement and those issues. But he recognized the disparity in income and awarded $2,500 in attorney's fees, yet gave mother credit for paying the $2,900 a month prior and going forward. So, I mean, it was kind of a double whammy. The prior expenses, attorney's fees expenses, and prospective child support, as if the litigation would go on. We sit here today, so yes, it has gone on, but awarded her, in essence, $2,900 a month in attorney's fees by taking it out of the child support calculation, and then awarded father $2,500, where clearly both parties spent $20,000, $30,000 on litigation that mother insisted upon. Father had filed a petition for modification at the court's insistence at a contempt hearing prior to that. So, and where father spoke up and said, oh, by the way, the children are living with me, and was told by Judge Porter in December of 2012, well, you better file a petition for modification. And so father filed his petition for modification, and in his ruling, Judge Porter, the first time he ruled, he said father was unreasonable by filing the litigation for legal decision-making. And then he changed it after our motion for reconsideration, saying, no, he was unreasonable for pursuing or not agreeing to the 50-50 parenting time. Well, the parties had an agreement since October of 2012 as to the living arrangements. So father didn't pursue any litigation on that behalf. Mother was arguing 50-50 parenting time after Judge Porter said at the first hearing, I'm going to find out what the kids want. They're 16 years old. And mother kept arguing 50-50 parenting time because of the numbers in the child support calculations. And so she was arguing unreasonably. She was unreasonably. Father wasn't unreasonably arguing. He was saying whatever the kids want, whatever Corey Short testified at the second hearing and said, this is what the kids want. And still, she pursued it until 2 weeks prior to the trial and then signed a stipulation agreeing to what the parenting time had been since 2012. Father wasn't unreasonable in that regard. I think Judge Porter just mistakenly put that as his reason for father being unreasonable, because he wasn't arguing it. Mother was arguing for the 50-50 parenting time. Father was saying just keep it as it is. So the fact that he filed the petition should not be used against him. He had to. He had no... Mother could have come and picked up the kids on a 50-50 basis, their prior parenting time schedule. And he wouldn't have had a court order. He was required to file the petition for modification. So father did not act unreasonably in any aspect in this case. And father, in fact, mother was told at the first or second hearing, I'm going to count your inheritance, what you're spending, as your income. Although he subtracted from that, and again, that's illogical to me, but Judge Porter said from the get-go, you're going to be attributed what you're making. And of course, it took 3-4 months before we got there again. Mother was so unreasonable that she didn't stop. When the kids moved in with Dad in October of 2012, when we got to court the first time, Mother refused to agree to stop Dad's child support. We had to go back 3 months later in order to get the wage assignment stopped, because while the kids are living with Mom, with Dad, Dad's still paying Mom child support. Mother was so unreasonable, it took me to file a motion to go before the court to say, you got to stop the child support coming from Dad. Not only he's supporting the kids by himself, but he's paying Mom child support. That's how unreasonable Mother acted throughout these proceedings.
Thank you.
Good morning. I am Andrea Lawrence. I am the attorney for Lori Curto, who is the petitioner in the underlying matter and the appellee today. I wanted to start by pointing out what I'm sure you all know, the standard of review being abuse of discretion. Case law finds that, or holds that, the appellate court accepts the trial court's findings of fact unless they are clearly erroneous, and abuse of discretion exists when the record viewed in light most favorable to upholding the trial court's decision is devoid of competent evidence to support the decision. That's the Jenkins case.
One of my questions is related to what you've just said, and we of course do spend a fair amount of time in lots of cases thinking about the standard of review and how it applies, what it does to us or for us. Is it an abuse of discretion if a trial court departs from the guidelines without explaining it?
It is my understanding that the statutes require a finding as to a deviation if there's going to be one. I do not believe that this was a deviation from guidelines. The question here, I think it hinges on the definition of income as opposed to cash flow available. There is a difference between someone pulling money to live off of and a set salary or wage that is being received as earned income.
But it's all income, because it's all income for federal tax purposes, which is what the guidelines say.
Of course, but there is also case law that says that income for tax purposes is not necessarily the same as income for child support purposes. In this case, one of the points that appellant makes is that all of the income that was shown on a 1099 statement should be used for calculating the child support. We disagreed and argued to the trial court that that money was not necessarily received into the household to be spent. It was transferred from accounts, from one account to another account for various reasons. She did end up paying tax on it, but she didn't receive all of it to spend. We presented to the trial court not only mom's testimony, but exhibits 35 through 42, which were all the account statements from mom's inherited IRAs and the tracing to show where it went. Exhibit 35 was a demonstrative exhibit that summarized that and showed that the money that mom actually received into her household was $125,000 and change, and that's the number that the court accepted. So in having evidence of both pieces and then further explanation and understanding of what actually happened to the money, the trial court accepted, based on the evidence presented by mom, that it was $125,000 that was brought into the household, not $160,000 as counsel suggests. Therefore,
125 would, with the subtraction of health insurance and attorney's fees.
the judge started with $125,000 and then from that subtracted attorney's fees and the health insurance, to be perfectly clear. So the health insurance, let me start with that. The health insurance was an expense that mom had that was fairly extraordinary in the amount of approximately $1,500 per month. She would not have been able, if she were employed in a position that allowed her to have health insurance such as dad did, then yes, the money would have been coming out from her paychecks. In this situation, mom was paying that health insurance up to a couple of months before the trial before the trial. So when the court deducted that from the amount of money that mom was having, it was saying that she's no longer going to be withdrawing $1,500 from an IRA because she doesn't have this expense anymore. Likewise with the attorney's fees, she's no longer going to be withdrawing $2,900 because she's not going to have that expense anymore, and we're looking at calculating child support going forward. So if she's not going to have those monies coming into her household anymore, she's going to be, further testimony then talked about how the accounts were effectively liquidated in any event. But
I understand what you're saying, but the definition of gross income is income from any source. And it doesn't, the starting point at the top of the chart, at the top of the worksheet is gross income. And you don't start, do you have any authority that supports the notion that you can start chipping away at gross income based upon deductions, if you will, like taxes or attorney's fees or health insurance? That just seems like way out there for me. I'll just be honest with you. It seems like way out there.
I understand.
Yeah.
We did not attempt to deduct the taxes. Talking about the attorney's fees, we needed to make a calculation or the court needed to make a calculation of child support based on the income that mom was having right now. And right now, she was no longer going to be paying $2,900. So I think that's the key where this is different from a salary. If, for example,
But paying $2,900, then it should have been included.
if she's not paying $2,900, it would have stayed in an account and it would have just been there as an asset.
But yeah, let's go back to that question. Under Cummings says it's all money or income that's available, all funds that are available for expenditure. I know that's a fuzzy term. What if all 700,000 and change, whatever, had been invested in invested and rolled over into different accounts? Then gross income would have been zero.
That's what I would submit. It would be the same as any other asset. That would be.
But it wasn't. But she withdrew large amounts.
She did.
For the purposes of sustaining her supporting her lifestyle, whatever it was. For expenditures, what lifestyle or not. Isn't that true?
So maybe.
She withdrew substantial sums of money over the 2-3 year period. Why wasn't the court, why wouldn't the court be able to just take those figures? There should be like dollar amounts of gross figures that were brought into her possession, and those should be counted as gross income.
Because what had happened in the past in 2013 and prior was not going to be repeated. It would be the same situation
I understand, but wasn't part of the problem here that the father was seeking past child support back? This is retroactive child support. Wasn't he going back into 2013, even into 2012?
Yes, but I believe that the trial court recognized that but for the litigation, that money would have remained an asset. It would not, and that may be a separate question as far as what's available to pay attorney's fees, but it would not have come into the house any more than, for example, home equity. If somebody has a paid-off house, the value of that house is not income, even though they could be tapping into it if they wanted to, but people aren't, so that's not included. Or their own retirement account. You could borrow from your 401k through your employer, but you don't, so that's not included in your income for purposes of child support. You have, credit available that you could tap into to spend money for your kids, but you don't, so that's not included. Just because it's available to be spent, I don't
I understand, but once you draw those monies into your account, and if the federal government takes a part of it, I mean, so did the trial court or not, I'm confused on what the trial court treated taxes.
The trial court didn't.
17,000 based on, is that pre-tax or after tax?
The 17,000 was, as I understood it, pre-tax, as is the 10,000 on the 125. We said trace the money and see that it's moving back and forth between accounts. It's going from one asset to another asset to this asset to this asset. Yes, it created tax consequences, but it didn't come out to be spent. And we had our Exhibit 35 funneled all of the money into what was in a cash account that Mom had in her checking account available, and that was the 125,000. And that was pre-tax, or excuse me, that was gross also. There was no tax consideration on either side, on either of the calculations by the court. And maybe to argue just a bit further on the idea of the $2,900 that was paid for the attorney's fees, we would be concerned that that would create a precedent that any source from which you pay your attorney's fees would also be income. If you cannot pay it, hypothetically, if you cannot pay it from your salary, you earn $60,000 a year, you can't afford an attorney out of that. If you take a loan against your house and you use your home equity to pay your attorney's fees, does that then get included? I spent approximately $3,000 a month on attorney's fees, but I took it out of my home equity. Does that now get added in so that now you have a $60,000 salary plus $36,000 that you had in fees? Or if you borrow it from any other source, or if you receive your fee money as a gift from family, does that then get included as income for purposes of calculating child support? I would submit that her taking the money from an IRA to pay her attorney's fees is no different than her taking money hypothetically from her home equity to pay attorney's fees.
But if your family gives you a gift that seems to be continuing over a period of time, case law says that's income.
Absolutely.
However you may spend it.
Absolutely, but I would submit that if you are receiving a gift for purposes of paying your attorney's fees, that's not necessarily and very likely would not be continuing. That's here I'm going to help you out.
That would ultimately be
We would usually
the trial
hope.
court.
Right.
To determine.
Hope it
Agreed.
would be continued.
Agreed.
Unfortunately, in family law, a lot of times it is.
Yeah, and that's very unfortunately. Let's see. I want to speak briefly to the issue of unreasonableness. I believe that's covered by the abuse of discretion also, and I think the court was pretty clear about that. What you don't have in front of you in the briefs, but do in the record, is that there was never any evidence that Mom had previously agreed to any parenting time arrangement through the parenting coordinator or otherwise. Father suggested that was true, but there was no evidence submitted to back that up. I don't believe that it is unreasonable, and I think the court agreed, for Mom to say, I really do want to have a 50-50 parenting time arrangement, at least with my children, when prior to that point she was the primary caregiver. There were substantial issues between mother and father that trickled down to the children, so her suggestion that there should be some review by the court as to why the children are saying they want to live with dad, I think was an important piece. The court ultimately ordered that mom and the children would participate with a therapeutic interventionist and appointed Dr. Selmy. However, the initial order on that was incorrect, and it took a number of months, and there's testimony about that in the trial record. It took a number of months to get that sorted out, almost 6 months. So that was a significant portion of the delay, not mom stomping her feet or insisting, but saying, yes, I want to participate in this process and preserve my relationship with my children. If you are all interested, that is at the trial transcript, May 5th, page 60, talks about how long it took to get the therapeutic interventionist appointed. Mother's testimony that there was never any prior agreement with the PC or otherwise, the parenting coordinator or otherwise, was at page 59. There was also the issue in the reasonable or unreasonable about the settlement offer that mom had made. The court found that her offer was reasonable. In the opening brief, there is suggestion that the calculations in the settlement offer were substantially different from what the court ultimately ordered. I would submit that that's not true. The math is correct. They were within what mom offered to use as her income versus what the court found was within a couple of $100s per month, and that was Trial Exhibit 54. There were certainly points that mother disagreed with, certainly things that she was disappointed with in the court's ultimate findings, but we did not appeal nor even cross appeal because we did not believe that these things were an abuse of the court's discretion. So just for purposes of illuminating where the court was going with some of these calculations, in the question of money being spent by mom to improve a house, for example, and whether or not that should have been included, the court did not include those dollar-for-dollar monies, but did include rental value of the property that she had purchased and rehabilitated. So certainly there was some, I don't want to say penalty, but some piece of that money was translated into the child support calculation. Likewise, mom was living in a house that was owned by her parents' trust. The court attributed to mom the full rental value of that house as income for purposes of calculating child support, despite the fact that there was testimony at the trial court level that mom was paying rent for that property. It was not the fair market rent, but she was paying $400 per month, and the court did not give her credit for that. There was testimony that I'm sure you all remember the trial was in May of 2014. So in addition to the testimony about the monies that mom had spent or received from her IRAs in 2013, there was also testimony about what she had done up to that point in 2014, which was substantially less. Despite that fact, the court went with the 2013 numbers, and that was explained on page 116 of the trial court transcript. Then mother testified further that the inherited accounts were all but depleted by the time of the trial, and she would not be able to continue to withdraw the sums of money to use for living expenses as she had in the past. And that was on the transcript, the trial transcript, page at 94, line 24 through 95, line 6. And there were the exhibits, the bank account statements, which I referred to before, exhibits 35 through 42, reflected that those accounts were depleted. Going back to the issue of the income and talking about what money is available in the house, what is being used to pay expenses, what is being used to live off of, there was a substantial amount of evidence that dad had additional sources which included his overtime. And of course, I'm aware of the statute saying that the court is not necessarily required to include overtime in calculation of income. But regardless, if we were applying a standard of what money was available in the house, then we certainly argued that it should have been applied evenly across the board, and should have been looking at the money in both houses, not just what was in Mom's. In addition,
I'm not clear that the court's calculation of father's income is before us on appeal.
This is,
You're sort of arguing by analogy here, I guess.
you're absolutely correct. But what I'm trying to point out is my understanding of the way that the trial court applied the various standards and case law. The court did certain things that were beneficial for father and certain things that were beneficial for mother. And in so doing, I think that was considered and recognized.
I think, excuse me for interrupting, but I'm noticing that we're getting real close to the end here.
Certainly.
And I'm probably going to ask something that's been asked already, but permit me anyway, please. I think as I understand the guidelines, the guideline 5, and Judge Brown was making reference to gross income as the starting point, and then guideline 6 sets forth certain allowed adjustments to gross income for spousal maintenance and child support, but it does not specifically list health insurance or attorney's fees. Is that correct, or?
I believe that's true.
And so
Likewise.
how do you argue to us that there was no deviation or departure from the guidelines?
The guidelines also do not say that income is from an inheritance. There is a laundry list of.
The judge seems to have accepted that. I mean, is there a bottom line argument here that none of the inheritance money should be included in wife's income?
Not at this point. With all due respect, that was early on an argument. I did. But yes, I agree with you. The court seems to have accepted that even though inheritance is not stated in the guidelines, that it counted for these purposes.
Yeah.
And I think likewise, even though attorney's fees and health insurance are not stated in the guidelines, the court accepted that mom should not be penalized for having to pay those expenses any more than father should be penalized for working the overtime or any attorney's fees that he paid. Likewise, there was testimony that father's live-in girlfriend was paying some insurances on behalf of father. That did not get included in father's income. Same way mother's insurance that she was being paid by her trust by her parents' trust did not get included in her income. I think the court was even-handed in its application.
Thank you.
Thank you.
One of the arguments I heard by counsel was talking about perspective. We don't base child support on what happens in the future. We base it on the income we're receiving today, not what we expect to inherit later or what we expect to spend next month. But as we sit at trial, that's our income.
Does it matter, and maybe this question is misplaced, and I'm willing to have you tell me that, of course. Does it matter if we're looking prospectively to setting child support, or if we're looking backward to set it in the past, fix it?
It doesn't matter, because then everybody would say, well, I'm making $20 an hour today, but I'm thinking of taking a job at McDonald's next month for $10 an hour.
Well, of course, then somebody would say, well, we're going to attribute more than.
Well, they could, but the argument would always be available for somebody to say, okay, well, I know I went out and I spent all this money for the last 3 years. This was a 4-year history of spending anywhere. The least amount was $160,000. That was the least of 4 years. There was $280,000, $380,000 were the 2 years prior. And these are the periods of time we're talking about the child support, because it was going backwards, not just going forward. So
It was clear that those funds weren't going to last forever. Those, in fact, I mean, didn't Mother testify the funds were gone? as
That's
far
what
as
she
the-
testified to, and we weren't allowed to ask Mother about her future inheritance. She was also receiving another large inheritance September of that year. But Judge Porter wouldn't let us ask that because that's a prospective application of the child support, and legally you can't base child support on what you're earning prospectively.
Ms. Lawrence argued in essence that the judge was even-handed, that the judge had discretion to include certain things on each side, subtract certain things. I don't know that she said this, but I think she was probably suggesting that it didn't have to be exact as long as it's generally even-handed. Isn't this all factually driven, and aren't we bound by our standard of review to give a lot of deference to what the judge has done here?
I don't think so. I think his abuse of discretion is irregular. He clearly abused his discretion in this case. I mean, even from the hundred,
some of
even
us aren't sure about whether the difference between abuse of discretion and a clear abuse of discretion.
yeah. Well, in this case, I mean, starting just from the $160,000, the argument subtracting Exhibit 35 because we transferred from this account to that account. Mother testified she spent $160,000. She had W-2s or 1099s justifying $160,000. She had a W-2 justifying $1,800 a month.
What if some of it was for improving investments? What if it was expended in the nature?
Then Mother could have shown evidence of that. She didn't for that year. Her evidence that is summarized in Exhibit 35, you will see, is because Mother was arguing transferring from one account to the other account and not having spent every dime of that $160,000, notwithstanding Mother's testimony that she did spend the $160,000. So the fact that she put it in one account from the other account doesn't make the income less. She withdrew the funds to create a tax event for $160,000. Then she had her regular salary, which was $1,800 and change. Then she was attributed the income. She was given credit for the partial rental. One was $800 and subtracted $400 that she actually said she paid, testified to that she paid, and the other was the value, the rental value. She was attributed that. Judge Porter didn't find that father got any contributions from girlfriend for his expenses. There was no finding made. So the argument that it's all even-handed is simply something that Judge Porter didn't find. He didn't say, that wasn't his reasoning. He didn't say that. He said, well, I'm going to subtract out $2,900 for attorney's fees, and I'm going to subtract $1,500 for Mother's health insurance.
Those are the abuses of discretion under your argument, as I understand it.
The $160,000, him putting it chipping that away to the $125,000 that he found was an abuse of discretion. He abused his discretion in subtracting out the $2,900 a month and the $1,500 a month. If we're allowed to say what we spend our income on is attributable to anything, I mean, because we're in this litigation, it's $2,900 a month I'm spending in attorney's fees, and that isn't what he did. He took a certain amount of attorney's fees and divided it over the period of time, coming to $2,900 a month, what Mother said her total attorney's fees were. So subtracted it from her income. Then we could do that in every case. Then why wouldn't father be able to say whatever he was paying me gets subtracted from his income, or whatever father's paying for his own health insurance gets subtracted from his income? I mean, the fact that Mother chooses not to be full-time employed because she has a large inheritance shouldn't give her credit. That's simply unreasonable. And there was evidence. I also wanted to point out there most certainly was evidence. Clu Davis, the PC, the parenting coordinator, clearly stated that the parties had agreed a year before when they went to see him, because they had to first go to a parenting coordinator before they could even file the petition for modification. They reached an agreement in his office as to the parenting time. Yet mother nevertheless argued that from the day father filed the petition until 2 weeks before the trial.
Thank you very much. We appreciate the argument of counsel in this matter. We will take it under advisement and issue a written ruling in due course. We stand in recess.